Dowry is a word hated by many, celebrated by some, and if anyone is found indulging in it, is punishable by law. The IPC section of 498A allows for immediate arrest of the husband and in-laws by the police on the basis of a woman's complaint and has been controversial. Several pro-male organizations have been protesting against the section, saying that the law is being misused by women for selfish gains and should include a penalty provision against its misuse. But women activists have been lobbying for no change in the law at all. Welcome to Gender Discourse. I'm Lottie Yalorik. This is a program that highlights gender issues. Continuing in our effort, we are back with yet another important gender issue. Our focus of discussion today is misuse of dowry provisions. To carry this discussion forward, I have in the studio an eminent panel of guests. It is my privilege to welcome Pinky Anand, who's a senior advocate, and sitting to her right is Smriti Singh, who's this young correspondent from Times of India. Sitting to her right is Mr. Shonee Kapoor, who's a member with the Safe Family Foundation, and to my left is Khadija, the human rights activist from Jagori. So I take this opportunity of welcoming all of you to the show. Well, before we actually ask our lawyer to explain this to us and simplify this a little for us, let's all take a look at this report.
What was created to protect women from harassment on the domestic front has been exploited by the weaker sex, or so it seems. Recent judgments by trial courts and high courts have made some stern remarks on the increasing practice by women using Section 498A as a weapon to settle scores with members of their matrimonial homes.
Husband needs protection. आदमी को भी प्रोटेक्शन की जरूरत है. मैं ये चाहूँगा कि उनके लिए भी कोई कानून होना चाहिए. अगर मैं ठीक हूँ, अगर मेरे साथ नाजायज हो रहा है, अगर मेरी वाइफ मुझे केवल ये प्रजम्पशन आप मान के चलते रहें कि मैं वो कमजोर है और मैं बदमाश हूँ, मैं ताकतवर हूँ, यह गलत है. इमोशनली आई एम वीक. ये कानून 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 ये कितनी महंगी महंगी आम आदमी कहाँ से लड़ेगा ये? हैं? ये कहाँ से वकील करेगा? इतनी एक्सपेंसिव ये लड़ाई है, कोर्टों ने खुद कहा है. और पब्लिक इंटरेस्ट में इस पर रोक लगाई जाए. महिलाओं को प्रोटेक्शन मिलना चाहिए, लेकिन साथ में उसको वार्निंग दे दी जाए पहले ही दिन से कि देखो अगर तुम गलत हुई और अगर तुमने इसको मिसयूज करने की कोशिश की तो आप पर हैवी पेनल्टी होगी और आपको जेल भी जा सकती हैं. तो 90% सीधा नीचे आएगा. ये एकदम सिर्फ 10 महिलाएं कोर्ट में आएंगी, वो भी फिर अच्छा ठीक तरह से साबित करेंगी कि बदतमीजी है, मैं सुरक्षित नहीं हूँ. ठीक है, उस आदमी के खिलाफ कार्रवाई होनी चाहिए. ये मेरी भी डिमांड है.
While for long the section helped destitute women to fight against harassment, in the past 1 year, courts have come across various incidents where women have misused it to harass the members of their matrimonial homes. The courts have not only voiced their opinion against the practice, but have also gone to the extent of calling it legal terrorism. The Union Law Ministry recently launched an exercise to tone down the provisions of Indian Penal Code dealing with matrimonial cruelty, including cases of dowry harassment. If the changes are implemented, dowry harassment may soon become a bailable offence. The changes are aimed at protecting family life and checking the alleged misuse of the law. Is the step taken by the government to check the alleged misuse of the law going to help, or is it a step backward for women? Legal experts believe that the overuse of the provision is being misrepresented as misuse, and if Section 498A is toned down, the larger female population is going to suffer because of a few bad cases. The provisions of Section 498A are not a law to take revenge, seek recovery of dowry or to force a divorce, but a penal provision to punish the wrongdoers. Bureau Report, Lok Sabha Television.
Well, I would like to begin with the lawyer on board today. So, Pinky, I would like you to explain this to us in very simple terms as to what does 498A really mean for the common people.
You know, in fact, Lottie, 498A came into being in 1983. Prior to that, there was no criminal law. So that if there was cruelty or if there was any kind of economic offense or if there's any kind of punishment for the woman, it was not punishable as a penal offense. In 1983, it was realized that all our laws which are dealing with dowry, because you know, ultimately in the Indian society there is still a lot of demand for dowry, and as and when dowry is not given, there is cruelty perpetrated. Marriages are even broken down on that pretext. I mean, whether the woman is beaten up or tortured or traumatized one way or the other, there is harassment. So it was felt that, you know, we have come into society which is far more developed than what it used to be, and so it is high time we address this issue, so that if a woman was beaten, if a woman was given mental ill treatment, if she was meted out any kind of trauma and torture in her married household, whether by her husband or by her father-in-law, mother-in-law, brother-in-law, sister-in-law, whatever the case may be, in that case she could file a complaint under 498A, which was for the first time made a criminal offence. And you know, it is very unusual because only in India we have such a kind of law. You don't have dowry practices in other countries in most places. So that's the reason. So therefore it was made an offence whereby if a woman made a complaint, she could ultimately seek a conviction of her husband or his family members, whoever they might be, and punishment up to 3 years. And I think that is what really changed the course of events as far as women's rights are concerned, in this direction of not being treated with cruelty.
Well, so which means that when it came to place, there was a reason for it to really come.
Absolutely. It was a long-standing demand. It didn't suddenly come into being. For the last decades over, basically it was felt, you know, the Dowry Prohibition Act was there earlier, but it was a toothless act. It could not give any results. So what you needed was a law which was able to provide relief to the woman, not only to seek punishment against the people who done wrong, but also actually for a means of a survival. A woman was normally thrown out of her house as and when she was tortured. She had no rights of inheritance. She could not take her even her clothes, leave aside anything else. All the Sridhan which was given to her at the time of marriage by her parents or even by the in-laws, what is called vari locally, even that she had no access to. Children, depending on the situation, children very often went to the woman. But nonetheless, there were situations where the woman, the child was there, even the child was withheld. So where would you go for relief? And therefore, it was felt that the laws as they stand, Hindu Marriage Act, for example, provide for what? Matrimonial disputes, for getting your divorce, getting your annulment. This didn't provide you adequate remedy for getting back your Sridhan, for getting back your rights, for getting, in fact, punishment for something that had been done wrong, which is, you can't beat a wife. I remember times when people used to say, if you went locally, somebody is beating his wife and you ask him, why are you doing this? He said, she's my wife, I can beat her.
I can beat her.
So you had to change the mindset, which wasn't changing in normal course. You needed to put into effect a law which was able to handle the situation, and that's how 498A came into being.
Right. So Smriti, do you think that, as Pinky says, that a number of women must have benefited from this law actually?
See, I feel there are a lot of women who have benefited. It's just some cases in which misuse, obviously when there's a law, there is misuse of it. It goes without saying. So yes, there is misuse, but yes, a lot of women are being benefited. It's like, first we have to see how many cases actually, make to the court. I mean, how many reach the court. There are still a section of females who are not that aware that they can go and lodge an FIR and do that. And there's so much cruelty happening right now also. So when we are talking about misuse of dowry, harassment, or any anti-dowry law, we have to see that which particular, it's a section of it. It's not the entire picture. So yes, we do report on such cases because that's where we need to make people aware that courts can also take a stern view of whatever wrong is happening and all. And court is not a toothless, a judge is not a clerk sitting there and just doing things and passing orders and all. It also has some sort of authority and where they can go around. So I think it's a great section and provision which is being given for women, and misuse of course is there, so we do it, but then I don't see any wrong with the 498A per se, and I think it should go on as it is.
Okay, well, let's get the gentleman's view here. So Shonee, you are a member of Safe Family Foundation. So what has your experience really been like, and do you think that when this came into place, was it really required then?
See, Lottie, let me start with saying that I am not a lawyer.
Right.
I have not studied the history as maybe Pinky would have studied or as maybe Smriti would have done a research on it. What I have done and felt is what I have felt on the street. Right. Now, coming to the misuse of it, number one, no section of the society today says that this section is not being misused. Right from the president to the courts, everybody is saying that this section is being misused and there is a need of amendments. Now, the question which Pinky and Smriti are raising, how much misuse is happening? Let me give you some statistics. The cases of dowry harassment being lodged in India is rising by the rate of 11% per annum. Only one state is not adhering to this trend, and that is the state of Delhi. The reason is very simple. In 2008, Justice Gambhir gave detailed guidelines that no arrest should take place unless certain things are satisfied.
Okay.
The result is, within 2 years, there is 35% decline in the cases registered in Delhi. Still, husband can be arrested, no other in-laws can be arrested. Now, if we say that just by making it bailable for a section of society, like relatives of the husband, the rate has come down by 35% within 2 years. Of course, there has been misuse. There has been certain women who are using it for vendetta. They have stopped using it.
It is not as if relatives cannot be arrested.
No, they can be arrested, but not on a prima facie complaint.
No, but
not on a prima facie.
They only require mention by a senior official. That's all.
No.
That's the only provision. Let's be very clear.
That is very clear. No, it is very clear that it is a very detailed guidelines. We state that at least if there is a Stridhan complaint, there should be some proof, prima facie proof that Stridhan existed in the first place.
That there is to be in any case.
No, ma'am, it is not there. In rest of the states, it's not there.
The CAW cells that have been set up, which are there for the last almost, I think, 7 years, subject to correction, they have been investigating all the complaints, and then only after the investigation is complete do matters go. There were only rare cases where this was sidestepped and something wrong happened. But aside from that, Justice Gambhir, of course, has done very good justice by making it statutory in a sense, by giving guidelines. But it is not as if he says no arrest. He says arrest after investigation, which is there. Arrest after senior officer's intervention, so that it cannot be misutilized.
So now this is the question. If, okay, supposedly you don't want to make it a bailable offence. The guideline should be that at least certain set of allegations should be prima facie satisfied. Whether if it is a question of Stridhan, there should be a list of Stridhan, whether it existed or not. There should be certain bails. See, Lottie, Pinky would correct me if I am wrong. There are rarely any arrest or any confinement for 498A, unless a person is arrested on the very first day. Generally, the bails are denied for 406.
Exactly.
Right? We are nowhere asking that 406 should be made bailable. Our only demand is 498A, vanilla 498A, as I state, should be made bailable and compoundable. Another thing which I want to raise is that matrimonial offences all across the globe, nowhere they are non-bailable offences. Be it bigamy charges, which are very serious charges, and the punishment is 7 years and 10 years, depending upon the situation. There are also bailable offences and non-cognizable offences. When Lord Macaulay drafted IPC, the reasoning he gave was that the reason matrimonial offences should not be non-bailable offences is that once a person goes to prison, there is very little chance left to save the marriage. And that is what the Supreme Court has recently stated in
all right. I think we need to interject here, as you asked if I have some comment here. But Lord Macaulay did this in 1800s. We are in
the society in
we are in 2011 at this point of time. Just hold for a minute. The issue is, when you make a situation, you mean to say that when a woman is beaten, when she is tortured, forget the recovery of Stridhan, that's one part, that is something which is not serious enough to be an offence. Normally if you hit anybody, that is an offence under penal code, Lord Macaulay's penal code. So if you hit your wife, Lord Macaulay thought it fit not to include that within the parameters of penal offences. So therefore, the whole idea is that you're coming into society which says, I'm sorry, you can disagree with your wife, but you can't beat her.
No, I agree, Pinky. I certainly agree.
Well, I would want her comment into this, but before that, I think we'll have to slip into this very short break. But people do come back quickly, as there's a lot more that we are going to tell you about 498A and whether it is being misused at all. Welcome back. This is Gender Discourse, and today we are talking about misuse of dowry provisions. Well, people, this is your chance to tell us as to what you think about the issue. You too can participate in this discussion right here, right now. All you have to do is dial 1800115313. That is 1800115313. Well, now I would like to have Khadija's point of view as to whatever is being discussed here. I would want, what is your personal opinion about this?
See, I belong to women's movement. I was a very young adolescent girl at 14, 15 years old when in the 83s, when I read in the newspaper every day many women being burned or killed, their families, right from very educated to poor to all castes and all creeds and all types. Bride burning was the in thing that time. It used to terrify me from very core of my heart, and thought of marriage was very fearful for me, because I used to think that marriage is a place where you are put into hands of criminals and where you can be tortured for just not bringing one cycle. You can be tortured. And that was the time when this whole women's movement went up. There were a lot of movement, a lot of work, a lot of agitations, and there comes a good new law which says that if you torture your wife for want of dowry or without dowry, you will be punished, and it's a criminal. And that was the time when I felt as a young woman very elated. Come, I am now free in this country. At least my life and liberty is safe, even in my matrimonial home, everywhere outside, and even in my matrimonial home, which was dreaded to be as the most insecure place for a young girl, an inevitable place. I have to be there and I have to be unsafe. There was this dichotomy. Now I've grown out of that era, and I'm in mother of a young daughter once more. She's in the same kind of time here. Once more, we started seeing increase of dowry deaths, increase of incidents of tortures of wives and daughter-in-laws in their place in your media reports. I feel so disgusting when my daughter is sitting next to me and you show a wife has been burnt or beaten or dead. This is a factor which alarms us, and because of this issue we went into a research, because gentlemen like these and everywhere people are talking that we are misusing this law. For women with whom I have worked, as I am a legal activist, I have been working with lots of women, hordes of women who have been facing violence at their matrimonial home. For women, Khadija, it's very threatening, threatening to know that this law is going to be subdued. As Pinky has mentioned, it is already being subdued. It's already, I cannot walk into a police station as I fancied in my young adulthood to complain about my in-laws or my husband's cruelty. Now I have to go through the hardship of CAW cell to file my complaint. Even though I am at risk of being murdered, even then I have to go through a civil process. So now we went into a research. We are about to come out with a document which wanted to investigate this whole quote-unquote misuse agenda. What we have found from our primary research of 5 police stations of Delhi, 1 year data we collected. From the whole Delhi we have collected, 5 police stations we have done the analysis. Out of these 5 police stations we found that if a woman is being murdered, even if the case is not filed under 304B, for 1 year there has been no arrest, it says pending investigation. And if contrary to it, if a man has been murdered, there has been an arrest and a challan and all kinds of things have happened within 3 or 4 months.
I would like Pinky's comment on this, but before that we have with us Kavita from Mumbai. So Kavita, if you're with me, welcome to the show.
हेलो
Yeah, Kavita, please go ahead.
हेलो मैडम, मुझे पूछना था कि मतलब जो मेरे ससुराल वाले हैं वो मुझे मेंटली बहुत टॉर्चर कर रहे हैं डाउरी के लिए, तो फिर हम लोग उसकी कंप्लेंट कैसे कर सकते हैं?
All right. Well, it's definitely a serious matter there, Kavita. So, well, I'll direct that question to the lawyer here. So, I'm sure there must be many Kavitas there who don't even know as to where to go and where to file a complaint.
No, you're absolutely right. But there are 2 sections of people. One who don't know what is going on and what are the remedies available, how they can go to the police station, how actually there is a law which says 498A is available to get you a conviction as well as reparation for what's happened to you. But there is another section which knows somewhat what the laws are, but are not in a position to utilize it either for lack of finances or for lack of stamina or for lack of even desire And actually, I'll add, there's a third category which doesn't want to go that route at all. You will still find there are thousands of people who say, we don't want to break up our marriage, they will tolerate this even if it's bad. So you're still having this entire cross-section of people, but as far as Kavita is concerned, she can file a complaint. And normally these days, I think this much we can be sure of, that investigation will be made on the complaint. And
लेकिन पिंकी उन्होंने पूछा कि वो कंप्लेन कहाँ करें, so वो आप थोड़ा सा उन्हें प्लीज समझाइए।
देखिए जो खदीजा जी बात कर रही थी कुछ हद तक सही है, that in Delhi, for example, if you go, you would now file such a complaint in the CAW cell. The Crime Against Women cell has put up cells throughout Delhi, and you would go and register your complaint there. On that complaint, notices will be sent to the parties against whom allegations have been made, and which allegations are found to be prima facie, as we say in law. Prima facie means on the face of it, that at least on the face of it there is a complaint made out against people, and those people are then called before the CAW cell. That CAW cell goes through a process of investigation as much as mediation, and tries to go through the process to ensure if it is possible to settle the matter. Settle the matter would mean both ways, whether the couple can go back together, or if the couple wants to separate, how to ultimately ensure that something best is possible, and to even ensure recovery. I think they play a very important role to recover the belongings of not only Sridhan. Sridhan is a bigger item. I'm saying literally
and
belongings in an
since
entire
this
way.
woman is from Mumbai, so where can she go and complain?
Mumbai, Mumbai also has certain provisions for these kind of centers. I don't know.
Walk into Mahila Thana.
That's right. I don't know what it's called. I said Mahila Thana.
Mahila Thane karke they call it.
Okay.
And she can walk into any police station in Mumbai, and the police station will direct to
Mahila. That's right. Well, so Smriti, you wanted to say something regarding
here
this.
I would like to make a point that, okay, fine, going to the police station and getting a complaint lodged, it all sounds very simple, you know, but it's very difficult to gather that particular courage for a woman who has been suppressed by her family, and to gather that courage to go to a police station, and then you never know. Most of the times police officials are not even interested. And for that you also need to be in touch with the lawyer. It's the lawyer most of the times. I mean, Pinky would agree with me that it's on the legal advice that 498A, a woman files a case. Most of the divorce cases as such, I mean, what I have seen in the courts, they will all be coupled with various litigations where the woman must have slapped 498A or, you know, some other Dowry Prohibition Act or something like that. So all these, approaching all these people is a difficult time. So what we see that this is a misuse, it's not being even used. So that particular
let alone misuse, right?
Let alone misuse. It's not
well. I'm having this the gentleman raising his eyebrows here, so I would want his comment here.
Yes, definitely. I like to comment on it. What Pinky said, what Khadija said. Now, Khadija raised a point of 304B, which is actually a different provision. It relates to dowry death. It does not relate to 498A. In effect, 498 does not speak about dowry anywhere. It does not speak about dowry anywhere. It is about cruelty and harassment. Cruelty be
talks about dowry also. One section talks about dowry.
It is valuable security. It is valuable security.
No,
it talks about getting the
section 1 speaks of
okay, ladies.
Yes,
all right.
Please let me speak.
Fine. He said in the beginning, you know, he's not a lawyer, so I'll grant him that. Yes.
Okay. Now, when you say 304B, the data which purported is purported to be 304B data. It is not in effect 304B data. It is 498 data.
Okay.
Right. Even in a very celebrated book, Super Freakonomics, it is a book which had been on bestsellers for 12 months continuously. On page number 5, it is written, 1 lakh brides are burnt every year. Actually, when you read NCRB data, it is around 8,000. And I'll tell you one more thing about 304B. Any accidental death or any death which is other than normal circumstances
within 7 years,
within 7 years of marriage is treated as 304B. A case is registered under 304B. Now next day or 3 days later, if the police confirms that it was an accident, it was not a dowry death, there is no effort made to delete that statistics from the data. Worldwide, youth deaths are otherwise than normal circumstances death. Either they are accidental death, maybe burning also. It is not that only in India the brides are burned or they are tortured. Yes, for whatever reason. The figures as per NCRB is around 7,000.
So are you saying lesser figures
No,
justifies an argument?
ma'am, you have not listened.
Go
You have
on.
not listened to me. You have not listened to me. Another thing. Now, when you club both these issues, and you start seeing 498A from the tinted glasses of 304B, of course you will say that, of course, there is a need for this to remain non-bailable. Tell me about any law. In 498A, a conviction can happen only on the basis of a girl proving that she was called black. She was taunted as being black. There is a Supreme Court order. 2 years conviction was meted out to a person for only stating that his wife was black.
I'm sorry, that is not so.
Yes, I can give you that judgment.
You cannot, because it doesn't exist.
I can give you that judgment.
I'm sorry.
I can give you that judgment.
On the contrary, Justice Kapoor in High Court categorically held that simply taunting is not something which justifies 498A. The exaggerations will not change the
I'll give you that
situation.
judgment. Pinky, I'll give you that judgment. Secondly, in this section, attempt of suicide is not must. A mere thought which has crossed the mind of attempting suicide is enough. Right? But tell me any other provision where 2 months old Zoya is granted anticipatory bail by Mumbai Session Court. Give me any other law where 3 months old Sono is confined to prison.
Okay, well, Khadija, I would like your interjection here. What is
See,
it?
my only thing is, like, I don't want to argue with him,
Right.
because that's not my point to argue with him. My point is to talk to my audience. My point of view is that 498A is essential. It has to be as it is. In fact, what my idea, it's not my own, it's like a voice of thousands of women who face violence at home. Being a citizen of this nation, we have to, under our constitution, we have to live a life free of violence, whether it is by my husband or by my brother or by my colleague or anyone out on the street. So this has to be as stringent as it is. In fact, my whole women's movement idea is that there's all counseling and all those police decision, whether it's a 498A or not, these all should go away, because in the light of Domestic Violence Act has come now, there is a space where women can go and file a non-criminal complaint against the family if it's doing violence, and she can take a litigation route by reconciliation route by PWDVA Act, and this should remain purely a criminal law, handling with physical and emotional assault on women by her matrimonial family.
That's
and
right.
it should remain pure law.
Okay.
It should not be, like diluted
In any which way. All right.
At the moment.
Well, then that is what some of my panelists do feel here, that it should not be diluted at all. Well, people do think about it whilst we slip into this short little break. But do come back quickly, as there's still a lot more on the other side. Welcome back. You're watching Gender Discourse, and today we are talking about misuse of dowry provisions. Well, people, I would like you to participate in this show. I would like to know whether you think it is being misused at all or not. Well, for that, you'll have to call us, and our number is the same, which is 1800115313. That is 1800115313. Now, Pinky, when we are talking about the misuse and everybody is accepting that it definitely does get misused by a certain section of women, so is it only the educated certain class which is educated, which is financially independent and who know what they want? Are these the kind of women who are actually misusing it, if at all?
Lottie, the point is, yes, there is some misuse, and I think I'll go with Smriti there, who said that if there is some use, there is always some misuse.
Yeah.
So that is always possible in law. But when you say this about which cross section, actually you're identifying the cross section which is primarily using the section in the first place. So obviously the question of misuse also arises, if
From
at all,
the same
within
section,
that.
yeah.
And rest assured, as we'll see, these are very stray instances. The only thing is they are publicized a lot. There is too much publicity given to these kind of negative cases, and it is because of that we start talking about it. But possibly if you take out percentages, it is not going to be that drastically high, because you are talking about percentages of women who are actually undergoing cruelty, then it will be absolutely a minimal percentage. If you talk about people who are filing complaints, then there is a proportion, and there is some misutilization which is being to some extent rectified by courts, incidentally. I think courts are playing a very dynamic role, and some of the particular judges
That's right,
have
which
given
we have
very
just
good
heard.
judgments, and we all go along with it. We are not here to say that every case should definitely, there should be a conviction just because there is a case. So as and when cases, there are wrong cases, there are made up cases, there are fabricated cases, then very well action may be taken. But to say, for example, that penalty should be provided, I'm afraid that will be counterproductive. The minute you do that, you will make women cow down under the entire pressure and say, "Tumne kara to you'll go to jail."
Yeah,
so, you know, that fear itself, as it is, there are a number of women who will not go.
As a detrimental.
Yes,
Yeah.
and then it will be a further detriment to say, you know, there is going to be a penalty at the end of the day. So even though on a larger sphere you may talk about these kind of provisions, but you don't have penalties in most kind of litigations in any case. Why this one?
Right. So Smriti, now as she just said, you know, these are some of the negative cases which get all the publicity. So is that right?
It is. I mean, courts are playing a really active role in bringing out all the, you know, if somebody is trying to misuse the law, they are completely upfront. There have been observations by trial courts, there have been some directions by High Court for the police, for people, for how to handle the case, that how you can, you know, deter this entire thing of not misusing. I would like to make a point. It's not about educated women and uneducated women. Whoever reaches the lawyer, it's mostly on the legal advice, that how to go about a case.
That's
and
right.
everything, and that's where all the sections come in. And as far as we are talking about misuse, why are we only focusing on 498A, where we are making such a huge discussion about the man is being arrested? There are murder cases in which men are arrested and later on they are acquitted. There is no recourse. I mean, and there are false cases. Fine, they are perjury charges that can be, you know, later on this thing. So it's always, there is a misuse, and courts are like, there's this, it was 2005 judgment by Supreme Court where somebody had moved, said that you should hold the 498A as unconstitutional and something. The court, Supreme Court said that although, you know, there have been instances where people are misusing it, and it's not like that, but then let the courts take their own course, let the courts handle such cases, and it can amount to legal terrorism, but then we don't think anything is unconstitutional about the section, let it be. So that's exactly, so why to just, if something is wrong with the law, we just don't go and throw it out and say that, you know, it's not working, it's just...
So let's do away with it or something.
Exactly, you
That's
have
right.
to be very clear about what exactly, I mean, how to, a law is just, you know, what I feel, a law is just something which is trying to tell you that this is what is right and this is wrong. How you interpret it is one thing. So let the courts do their work. I mean, we shouldn't be saying that, okay, repeal the law, or, you know, tone it down or something like that.
Okay, well, let's see what Shonee wants to say here.
We are not saying at any place that repeal the law. Only thing we are saying, make it bailable and compoundable. The only thing we are saying, bailable and compoundable. Bailable because if there is a misuse, the person is not arrested. There are 2.7 arrests made in every 498A case, which is more than any other in IPC except rioting. Except rioting, it is more than in any other IPC provision, 2.7 arrest. Another thing,
2.7% is not a very
2.7 arrest per case, ma'am. 2.7 arrest per case.
Okay.
Right.
Yeah, please,
2.7 arrest per
please.
case. Another thing we are saying, make it compoundable, so that the person, if the couple genuinely feels that there was certain, either on basis of wrong advice, the case has been filed, the case should be withdrawn and they can carry on with their lives. The only two things we are stating, make it bailable and compoundable. Yes, if a person has asked for dowry, if a person has treated his wife with cruelty, he should be punished, and he should be punished severely. He should be punished.
Right. So Khadija,
And
do you agree with him?
another thing which I wanted to add, just another thing.
All right, very quickly.
Another thing which I wanted to add was that we have seen complaints, and a number of complaints. They are not similar complaints. They are same complaints. If you remove the names, you cannot tell one complaint from the other.
So which means it is the lawyers who are actually...
Yes. There are 5
all
sets. There are 5 sets of complaints in Delhi. And if you remove the names, you cannot tell one complaint from the other. The same dates, instance.
That is
That's
on
right.
legal advice, how, you know, people... Most of the complaints might be genuine, but to what degree you take the complaint and what you turn it into is something on the legal advice. So that has to be checked. I mean, that's again my point, you know. Law is not wrong. The way people are executing it, the way it's being handled, that has to be...
Well, Khadija, I would like your point here. When he says that it should be made bailable and compoundable.
My idea is, like I told in the beginning itself, it's if somebody does a criminal assault on me, whether you are my so-called husband or whomsoever you are, this state has the responsibility under my constitution, to which I am also a equal national to this country as the gentleman is. So the state has the responsibility to protect me and give me a way for getting justice, a system to get a justice. I'm very sorry to say that today's Indian women, especially Delhi women, if I am assaulted by my husband or my in-laws, I don't have a criminal recourse as any gentleman is assaulted by any other gentleman. I cannot go directly to the police station and file a complaint and get the person arrested and get the case started. No, I have to struggle in the CAW cell for 6 to 7 to 8 months to get my FIR lodged. So in a way, by making this 498A already a very diluted case, my human rights, my fundamental rights is being not given to me. Not given to me. So my issue is that what he says, that 2.7% of the family is being arrested. At my desk, in my office itself, it's a very small organization, it handles a very small number of people, population. At my desk, there are more than 37 cases lying where the woman has been physically assaulted. She has a broken limb, she has a broken head, she has medical evidences of being physically injured by the family. Still there's no FIR, still there's no arrest.
But
what the law is going to say that?
For assault, there is a different provision.
No, there isn't any different.
498 is there.
325 is there. 325 is there.
No, 498.
I don't know whether we'll ever reach a consensus here, but Shonee, all right. Well, at this point, we'd like to show our panelists as well as the viewers as to what does the common man think about 498A and about its use or misuse. Let's take a look.
498A को normally ladies ने उसको एक actually it's more of a profession which has they have started taking it as a profession, harassing the in-laws without any logical reason, and police support them like anything. I mean,
though the statistics speak against the Dowry Act, but I still feel that this act does give women who are actually troubled by their by their family, it gives them a power. So I don't feel it should be changed or abolished.
People say that it's been misused, and it's been misused against their own husbands at times, but I think that's something that they just want to use against women.
डॉरी एक्ट तो 90% तो सब फाल्स है पूरा, क्योंकि ये ना सब लेडीज जरा ऐसा हस्बैंड वाइफ में तो होते चलता रहता है, परिवार में रहते हैं तो चलते रहता है, तो ये मिसयूज ज़्यादा होता है इसका.
डॉरी एक्ट डेफिनेटली मिसयूज होने लगा है आजकल, और डेफिनेटली अगर ये मिसयूज हो रहा है और जो मिसयूज कर रहे हैं उनको पनिशमेंट मिलना ही चाहिए.
सर्टनली जो मेट्रोपॉलिटन सिटीज़ में तो मिसयूज ही हो रहा है डाउरी का, क्योंकि गांव में भी डाउरी होती है और अपनी एक्सपेक्टेशन से ज़्यादा होता है. लेकिन डाउरी में जो पंचायत सिस्टम है थोड़ा बहुत, और वो भी 1% जो एजुकेटेड है गाँव के और वे बाहर सेटल हो जाते हैं, उन्हीं के केस बनते हैं. अदरवाइज तो ऐसा कुछ गांव में देखने को नहीं मिलता. तो शहरों में इसका टोटली मिसयूज हो रहा है. इसमें चेंज ही लाया जाए तो ज़्यादा बेटर है कि जो डाउरी दी जाती है उसकी लिस्ट इमीडिएटली कंसर्न SHO को दे दी जाए.
कि इस चीज़ का गलत यूज़ हुआ है और इस वजह से कई लोग आत्महत्याएं भी कर रहे हैं. इसकी वजह से किया है उन्होंने, और चूँकि ये ऐसा एक्ट है कि टोटली लेडीज़ को सुरक्षित रखने के लिए किया गया था, लेकिन ये चीज़ें लड़कियां जो है इस चीज़ को गलत वे में ले रही हैं और अब वो इसकी आड़ में लड़कों को शोषित कर रहे हैं.
डाउरी से संबंधित केस में अच्छे परिणाम भी आ रहे हैं और बुरे भी आ रहे हैं. अच्छे परिणाम इस सेंस में आ रहे हैं कि औरतों को, महिलाओं को एक सुरक्षा का आधार मिला है कि कानून में कहीं ना कहीं जाके उनकी बात सुनी जाएगी. लेकिन कई मायनों में, कई केस में ये भी देखने में आ रहा है कि महिलाओं के परिवार वाले इसका दुरुपयोग करने में महिलाओं का साथ देते हैं और कहीं कहीं परिवार बिखरने की.
Well, totally mixed views over there, and I would definitely like the reactions of my panelists on those. But before that, we have with us Ashish from Kanpur. So Ashish, if you can hear me, please go ahead.
Yeah. First of all, good evening, everyone. What I want to say is that laws are always meant for the governance of the society, and society is always dynamic in nature. It's not stagnant. It's keep on changing. Therefore, there is always a need of amendments, continuous amendments. Otherwise, a section of people would always be there who would be taking an undue advantage from this. Right. So I just want that there should be a need of changing law.
Okay, well, thank you so much for that point of view. Well, now, Pinky, I'd like to start with you as to what do you make of the discussion, what the gentleman just said, and about what all these people have just said.
I'll tell you one thing. This much, you're right in saying that some people have said that there is use and some people are saying it is misuse. But while watching, my initial reaction was this, that you can identify whether they are the in-law side or the girl side. Because the girl side says it's being used, and the men's side, the husband side, so to say, and the in-law side says it's being misused. But I don't think anybody can get away from this, that the entire fiefdom, if you might say, that of men, and their families included, who used to feel that you can do anything with a woman, actually you're taking away some power from them, you're taking away some strength from them. They feel that's a show of strength, that I can beat my wife, or my meri bahu hai, so I can hit her, or whatever it may be. She can't go outside the house. So I think you are taking away some kind of strength from a group of people. Therefore, obviously, there will be resistance. There is no issue that there will not be resistance. And I think you'll equally much find, there's one comment here that he had made, which I wanted to get back to. He says, you know, it should be made compoundable, because then families can get back together. Once a woman has gone to a CAW cell or to a police station, Mahila Thana, or whatever the case may be, they've actually gone after a long time and long thought. People don't just walk into thanas, and women don't do that. They weren't made for this, and still they don't do this. So, you know, the whole concept is, look, there has been extreme wrong committed. If I have been hit, if a woman has been hit, she has a right to seek protection in all senses under the IPC, and you have made a special provision, because earlier 325, as he was saying, was never used for women, never used for daughter-in-laws. It was only used in regular social context. So you have to have your society, your society's problems, your society's ills, and you have to address them. It is being successful, nobody is arguing. You know, Justice Bhandari in that judgment of Supreme Court, in fact, to get the other courts, Supreme Court, for example, quashed the charges against the brother who was living in another state.
Pinky, I'll have to interrupt you just for a moment, because we have this view online. This is Mrs. Kapoor from Delhi. So, Mrs. Kapoor, if you're with me, welcome to the show, and very quickly do tell me what is it you want to share with us. Yeah, Mrs. Kapoor, can you hear me? Well, while she tries again, we'll have to slip into this very short break, but people do come back quickly, as we'll be back in just a moment. Welcome back. This is Gender Discourse, and today we are discussing misuse of dowry provisions. Well, people, at this point we are joined by Mr. Rajkumar Sharma from Delhi. So let's see what Mr. Sharma really has to say here. So if you're with me, welcome to the show.
Hello.
Yeah, please go ahead.
मैडम, मैं ये बात कहना चाहता हूँ कि डोरी लेना और देना दोनों अपराध हैं।
जी।
एक बंदा जब डोरी देता है तो उसको कहा जाता है कि तुमने डोरी लिया, तुमने अपराध किया है। और यही बात जब बंदा डोरी देता है तो उसको क्यों नहीं पूछा जाता कि तुमने ये अपराध किया क्यों? क्योंकि जब ये अपराध हम उसको मान लेंगे कि उसने अपराध किया, तो आगे से वो डोरी देना बंद कर देगा। मैंने अपनी बहन की शादी में कार दी, उसने दी, लेकिन जब मेरे रिलेशन खराब हो गए तो मैंने उसको डोरी में कन्वर्ट कर दिया। सेकंड थिंग इज कि डोरी जब देने के लिए आया तो लड़की ने कहा जी हमने सोना दिया, ये दिया। सोना कितना दिया? 3 साल पुरानी बात होगी, बिल प्रेजेंट नहीं कर सके। 100 तोला सोना दिया, किसने दिया? कोई बिल नहीं है, मेरी दादी ने दिया। क्या एक दादी के 4 बच्चे हैं और उसके 20 नाते पोते पोती हैं, क्या उसने हर पोते को सोना दिया? और उन्होंने जो बिल प्रेजेंट किया वो सिर्फ बनवाई का किया, दैट इज 12,000 ओनली। तो मैं ये कहना चाहता हूँ कि अगर एक लिस्ट होनी चाहिए जिसको बहुत शादी करने से पहले वो साइन करना चाहिए, ये हम दे रहे हैं जी, ये है, ताकि अगर एक बंदा 2 लाख किया है तो कभी डिस्प्यूट नहीं होगा। 2 लाख को वो 20 लाख बता के बताता है जी यही डिस्प्यूट है।
Right. Thank you very much for that point of view. Well, Khadija, I would like your comment on this. कि वो कह रहे हैं कि पहले से हर चीज लिस्टेड आउट होनी चाहिए।
मैं 2 चीजें कहना चाहूंगी। एक तो ये कि मुझे समझ में नहीं आता कि हमारे मर्द जो हैं वो इस कदर परेशान क्यों हैं। अगर आप मैं एक जागोरी बहुत स्ट्रांगली बिलीव करती हूँ, और मैं उसको बहुत स्ट्रांगली बिलीव करती हूँ कि men of quality are not afraid of equality. अगर आप खुद अपने अंदर क्वालिटी रखते हैं, आप खुद मुजरिम नहीं है, तो आप लॉ से क्यों डर रहे हैं? सिंपल बात यह कि कितना स्ट्रिंजेंट, मैं तो कहूंगी कि कितना भी सख्त से सख्त लॉ बना दीजिए, मैं अगर कानून को पालन करने वाली हूं तो मुझे क्यों कानून से डर लगेगा? सामने वाले को जितने मर्जी उतने अधिकार दे दीजिए।
Well, Shonee is smiling very meaningfully. Let me get his comment here.
सिर्फ एक बात बोलना चाहता हूँ कि कितने भी सख्त कानून बना दीजिए, मुझे उससे क्यों डर लगेगा अगर मैं निर्दोष हूं तो? बहुत सिंपल सी बात है जी। अगर मैं निर्दोष हूं पर मेरी से ये नहीं पूछा जाता कि आपने ये अपराध किया है नहीं किया, मेरे को ये टाइम नहीं दिया जाता कि मैं अपने प्रूफ दे सकूं या नहीं दे सकूं। पुलिस मेरे को कहती है कि ये प्रूफ जो है अदालत में दिखाना, और मेरे को पकड़ के जेल में डाल दिया जाता है। हफ्ता 10 दिन मैं जेल में रहता हूं, इसलिए घबराते हैं। और क्वालिटी ऑफ मैन आर नॉट अफ्रेड ऑफ इक्वालिटी। आई विल टेल यू दिस, गेट इट वेरी स्ट्रेट, वी आर ऑल फॉर इक्वालिटी ऑफ वुमेन एंड वी वांट इक्वालिटी ऑफ वुमेन, वी वांट एम्पावरमेंट ऑफ वुमेन। बैसाखियां मत दीजिए लड़कियों को, मेक देम रिस्पॉन्सिबल सिटीजन एंड कैपेबल सिटीजन, don't give them crutches. Secondly, another thing which I wanted to add about this use misuse debate, the data of course tells something. Only conviction rate of 2%, which is lowest in any of the penal provision world across. It cannot go beyond that.
Well, Shonee, I'll have to interrupt you just for a moment as we are joined by this viewer from Bikaner. This is Mr. B.K. Dhanna. So if you're with me, do tell me what is it do you have on your mind? Yeah, Mr. Dhanna, can you hear me?
Yes, please. Yes, please.
Yeah, please go ahead.
मैडम जी, मैं ये निवेदन करना चाह रहा था कि मेरी बहू 5 साल तक हमारे साथ में रही, हमारी एक पोती भी हुई है। उनकी आर्थिक स्थिति खुद की कमजोर हो गई, उनके मेरी बहू के माता पिता की जी। तो उन्होंने हमारे पे एक झूठा केस कर दिया, मेरे पे, मेरी वाइफ पे, मेरे बच्चे पे, मेरे साड़ू पे और मेरी बिटिया पे, जो दूर देश शहर में भी रहती हैं। पुलिस वालों ने भी हमारे को पुलिस अच्छे तरीके से सपोर्ट नहीं करा। वो तो हम सही तरीके से प्लेस कर पाए चीज को कि हमने ऐसा नहीं किया। बच्ची होने के बाद, पोती होने के बाद सही तरीके से फैसिलिटी होने के बावजूद भी उन लोगों ने हमारे को हरेसमेंट किया और हमारे पे नौकरी पे भी एक तरह से बट्टा बैठने लग गया था। वो हम चूंकि एडमिनिस्ट्रेटिव ऑफिसर हूँ, पब्लिक रिलेशन ऑफिसर रहा हूँ, तो हम अपनी बात को सही कर पाए। अब वो तलाक की स्थिति में आई है और केस का तलाक हो रहा है, तो इन बच्चों ने, ये बच्चियों ने हमारे ये इसका डोरी का मिसयूज किया है। ये मैं कहना चाह रहा था, ये मिसयूज नहीं होना चाहिए और समाज को और पुलिस को इस बारे में सहायता करनी चाहिए कि पुलिस जो ना जेंट्स लोग भी हैं इस वाले, उन लोगों को हरेसमेंट नहीं होगी।
थैंक यू वेरी मच कि आपने हमसे अपनी पर्सनल स्टोरी इस तरीके से शेयर की। पिंकी, आई वुड लाइक योर कमेंट नाउ। आई एम श्योर दिस इज नॉट जस्ट वन केस इन आइसोलेशन, देयर मे बी अ नंबर ऑफ दोस।
I'll tell you one thing which definitely is brought out is that you should have laws which protect a section of society. It is not, you need crutches at some point. Call them crutches, call them Baisakhi. You can't belittle the situation to say women are a deprived lot starting out in society like this. One is coming up to somewhere further up where you are treated with dignity. I'm not even talking about equality. I'm talking about basic dignity where there is no assumption that you can beat a woman mentally or physically and thereby harm her or injure her. So you require a law, and I am glad that we were able to come around in this situation. Now again, at this point of time when there is some possible misuse, there is. I'm not disputing that.
Because also he had a point when he said that nobody even asked me, nobody asked the man whether he's done something like that.
All these statements are made in the extreme. For example, he talks about 2% conviction rate. 2% conviction rate because most matters are settled. There isn't conviction, there isn't full trial at all. Therefore, I say statistics are a hopeless example. One sees some general situations to say this, that they achieve the net result. 1 is return of dowry, 2 is return of their belongings, 3 is return of their getting of financial orders, even maintenance and other things. 4th is actually paying a price to society for what you have done. Because please remember, this cruelty of any kind, beating of any kind is an offense against the state. It is not against only a individual.
That's right.
Talking about making it bailable, it is very nice sounding, and there may be some observations whether by courts or by the law commission, but rest assured that we have to see the practical realities in our country. Make it bailable and you throw it away in any case, then don't have it. There's no point of having it if you're going to make it bailable. It will not work. The solution to some extent which has been found by these mediation councils, though Khadija differs with me there, but they actually serve their own purpose in trying to sort out the matter. I think it is a nice mix, and I think what the best thing is being done is by the courts. You are actually laying down guidelines, you are quashing bad cases, you are laying, for example, Justice Gambhir's judgment.
That's right.
I mean, a beautiful judgment which lays down guidelines to say, please do X, Y, Z before you come to the last mile.
Right, right.
So that is
Pinky,
where
we just have time enough now to take this viewer. This is Mr. Sharma from Delhi. So, Mr. Sharma, are you with me?
Yeah, you know, my case is because my daughter-in-law, she was with us for 6 years.
Right.
And we had a daughter, granddaughter also, more than 5 years. Now, after 6 years, you know, because of something, you know, I don't know what happened, and she was never mixing up, you know, with the family, and she made a false complaint. And the height is because we happen to, you know, her brother is a liar and her father is a liar. Now we are in a fix. Now the case is in the cell, you know, We have put a lot of, there is not even 1%, truth in what she has said. We are, day and night, we are not sleeping. In such a bad shape we are.
That's right.
We are
Mr. Sharma, I do sympathize with you there.
Grandchild, she has taken away the child, and it's a lot of botheration, and we do not know what to do now.
That's right.
And there is not 1% truth in that. And when we go to the lawyers, the lawyer says, भाई ऐसे है कि वकीलों की तो वकील ही सुनते हैं, आप समझौता कर लो. और समझौता कैसे करें? वो क्या कहते हैं वहाँ मीडिएशन में कहते हैं हमारा तो 80-85 लाख रुपया बनता है.
Thank you very much, Mr. Sharma, for joining us. Well, Smriti, one does come across cases like these also. So I would want your reaction on this.
See, that's what, the kind of example that the gentleman just gave. I cover legal issues. I come across, every day I come across such cases where I'm getting letters, mostly by men saying that their wives have, slapped a false case against the entire family and everything. So I think this particular issue has become more of a battle of sexes than, anything else. Men, okay, I do a story against misuse of law. I get 50 comments all by men. And they're all supporting that it's wrong and all. There'll be a few by women who have a very, a balanced view on this particular thing. And so what I'm saying is it's very difficult to establish who is right, who is wrong at the face of it, prima facie, as she said. It's very difficult. So you have to undergo a trial, and the courts are doing a brilliant job by acquitting people who are innocent, by discharging them at the stage. I mean, not even when the trial has not even started, they discharge them, they pull up the female family. There's another question which, there was another incident that another gentleman had called, that there is no people who give dowry. That's also an offense. There has been about 5 to 6 orders by courts in the past 1 year where the courts have initiated criminal proceedings against women and family of women for giving dowry and all. So I think everything is being done, as it should be, and things are completely fine. I really don't know why there is an uproar.
Well,
about
those are your final comments. Things are really fine, but very quickly, since we just have about a minute to this, finally, do you think that
there is no battle of sexes, because for every dowry harassment case, there are other females involved in the case, and especially sister-in-law, married sister-in-laws, maid party, so that there is a problem at her family. And that is why they should come on a settlement table. There is no battle.
Well, I think with that, I'll have to call it a day, and I'll have to say thank you to all of you for coming and sharing your views about misuse of dowry provisions. Well, people, laws are made for clear functioning of society as a whole. But if some laws, due to their sheer possibility of being twisted and getting misused, become a norm rather than an exception, then it is time that the lawmakers who need to take a deep look to see whether it's time to amend them. Terming the misuse of provisions of dowry harassment by women as legal terrorism by a trial court has come as a welcome step, as it slammed those women who, in a bid to settle scores, drag all family members into a dowry harassment case, though they may be totally unconnected with the case. So one can only hope that things would get better in future. So on that hopeful note, it's time to wind up today's gender discourse. I promise to see you next week with another engaging discussion on some other important gender issue. Till then, this is Lottie Alaric saying goodbye and take very good care of yourselves.